Today we have three cases that are scheduled for argument. First case we have is case number C210308, Duke Energy One Incorporated versus Cincinnati State Technical and Community College. If counsel can please identify themselves and their readiness to proceed.
Good morning, Your Honor. Bob McMahon on behalf of Duke Energy One. And yes, we are prepared to proceed.
Thank you.
Good morning, Your Honor. This is Elizabeth Smith on behalf of Cincinnati State Technical and Community College, ready to proceed.
Thank you. Counsel, would you like to reserve time?
I'd like to reserve 5 minutes, Your Honor.
5 minutes. Whenever you're ready, you can proceed.
Thank you. And may it please the court, counsel. As the court is well aware from the briefs that have been filed, Duke Energy One filed this action to recover its electric equipment from Cincinnati State. In response, Cincinnati State argued this case cannot go forward because of the prior Court of Claims case somehow meant that the amended complaint does not state a viable cause of action, or that the Court of Claims decision somehow divested the trial court of subject matter jurisdiction. In reality, it wasn't until the Court of Claims entered its ruling that Duke Energy One had a claim to recover its specific personal property from Cincinnati State. And there is no question that the trial court, the Hamilton County Court of Common Pleas in particular, has subject matter jurisdiction on an equitable claim to recover specific property from the Cincinnati State. Here, the trial court erroneously dismissed Duke Energy One's amended complaint based on either Civil Rule 12b1 or 12b6. It's unclear. In both instances, the court did so incorrectly because the amended complaint states a viable cause of action. And again, like I said, the trial court has subject matter jurisdiction. Therefore, the court should reverse the trial court's decision and remand this decision for further proceedings on the company's amended complaint. As we've argued in the briefs, Cincinnati State claims that Duke Energy One cannot proceed because Cincinnati State likes to say Buchanan Bridge and its progeny prevents Cincinnati or Duke Energy One from recovering its personal property. In reality, this is a case of first impression in Ohio. No court in Ohio has ever allowed the state of Ohio to take ownership of a private company's personal property that had not already changed hands before a contract was declared void. And that's a critical fact. Seems to be lost here maybe in the briefing, maybe in the pleadings, but I shouldn't say in the pleadings because it's very clear in the pleadings. In the amended complaint and in the attachment to the amended complaint, it's repeated that Duke Energy One owns this equipment. The parties always intended that Duke Energy One would own the equipment. At the end of the contract, Duke Energy One would take the equipment back unless Cincinnati State decided to purchase it. That's set forth repeatedly in the amended complaint and in all of the contractual agreements that are attached to the amended complaint and therefore become part of the amended complaint. And therefore, as the court is well aware, the court must accept those factual allegations as true for pleading purposes. Response to, with respect to the Buchanan Bridge argument, Cincinnati State likes to say, well, this court should leave the parties where they place themselves. And they say that several times in their briefing. Well, in reality, in Buchanan Bridge, that company had already incorporated all of the materials into the bridge. It delivered the product to the state. It already built the bridge. The bridge had already been open to the public and had already been used by the public. Ownership title to those materials had changed hands. So once the parties understood that the materials were being sold, that was the intent of the parties. That wasn't in dispute. So yes, the parties in that case obviously did not follow the law. This is I think this case is in the 1890s. The parties did not follow the law in multiple ways beyond just the treasurer's certificate at issue in this case. There were multiple other deficiencies in the contracting process, including going through the public process of advertising the contract. But beyond that, there's no question that the intent was there to sell to the state. Here, the intent is clearly the opposite. So when Cincinnati State says, well, in the Court of Claims case, the court left the parties where they may, and that's the binding holding in the Court of Claims case. Well, all that decision said was, yeah, them where they were. Well, at the end of that case, Duke Energy One remained the owner of the personal property, the electric equipment, and it simply couldn't recover money from Cincinnati State. That was it. So what did we do? We then filed suit to recover the personal property. There was no reason to do so before. Cincinnati State claims we had to seek the personal property in the Court of Claims case. We had no reason to do so before the Court of Claims declared the contract void. It would have been premature. To do so would have invited, quite frankly, an argument or a claim that that we were filing frivolous claims or filing baseless litigation. Once the Court of Claims declared the contract void, only then was the issue ripe for adjudication. As we've alleged in the amended complaint, the ownership of the property had never been in dispute until after the Court of Claims entered its decision. Not once did Cincinnati State assert the right to keep the electric equipment before the Court of Claims ruling. Not once.
Mr. McMahon, let me ask you, I have the trial court's entry dismissing the case under 12B1 and 12B6. And other than your amended complaint, what did the court have before it in order to make that decision? And were those materials properly in front of the court? Let me ask you this. Apparently your original complaint's not part of the record. Looks like the Court of Claims decision was attached to the motion to dismiss. So my question is, were those items properly considered by the court in a motion to dismiss?
I don't believe the Court of Claims decision was properly considered by the trial court. I think on a 12B6 decision and a 12B1 or 12B6 motion, a 12B1 motion, the issue is the amended complaint. And certainly on a 12B6, the court cannot look outside the four corners of the amended complaint. And the amended complaint includes not only the document, but also all attachments thereto. And the decision from the trial court, from the Court of Claims, was not attached to the amended complaint. On a 12B1, I do acknowledge, though, that the court can go outside the pleadings to a certain extent, but I don't believe that the court necessarily can go into the decision from the Court of Claims, but I also don't think the Court of Claims decision necessarily changes the analysis here. I don't think the Court of Claims decision indicates that the trial court does not have subject matter jurisdiction over Duke Energy One's amended complaint in this case. The claims decision was about that action was about an attempt to compel arbitration and an attempt to get a declaratory judgment to compel arbitration and a breach of contract for money damages only. That's it. It wasn't about property, and the issue of ownership and possession was never adjudicated. It was never questioned. Again, as alleged in the amended complaint in this case, no one, Cincinnati State, never claimed they had the right to own this personal property and to keep it for the rest of perpetuity. This is not a sale transaction. Buchanan Bridge was lease transaction. Under the state's theory of this case, Cincinnati State is essentially saying they could enter into a lease for a $50 million building with Duke Energy One or any other private company, lease months or years down the road, and say, oh, sorry, you don't have the treasurer certificate. Not only can you not recover money, but we're now taking your property. We now own your building. Sorry, the Cincinnati State essentially says in its briefing, they almost say tough luck.
Mr.
That's how
McMahon,
dismissive
Mr.
it is.
McMahon, the facts here are a little bit different, and that the property that you're seeking to recover is actually on Cincinnati State's real property. So I'm not sure that your example
Oh,
is
you
on point.
well, you are correct, Your Honor, but in the documentation that is attached to the amended complaint and is alleged in the amended complaint, the parties agreed multiple times and acknowledged repeatedly that it's personal property. It has always meant to be personal property. They did not agree that it would become real property belonging to Cincinnati State. Always. And there's no question about that. And we never got to that point. But for purposes of pleading at this stage, again, this is an allegation that for pleading purposes on a motion to dismiss, the court must accept as true. And the trial court never even got to that point.
Attorney McMahon, you have about 30 seconds left.
Bottom line here is for a standard of review on a motion to dismiss, either on 12B6 or 12B1, the trial court erred by dismissing Duke Energy One's amended complaint. Court of Claims case is not controlling here, and nothing that this court does reverses or changes the Court of Claims decision in any way, shape, or form. And for Cincinnati State to suggest otherwise, I think, quite frankly, is an attempt to somewhat question this court's authority, and when this court absolutely has the authority to and the power to reverse the trial court, and that's exactly what should happen. Thank you.
Thank you. Attorney Smith? Whenever you're ready.
Thank you. Good morning, Your Honors. I am Elizabeth Smith with the Voorhees firm. I, along with Chris LaRocca, who is with me today, and Mr. J.B. Lind, represent Cincinnati State in this case. Dr. Chris Calvert and Dr. Laura Baumann are also observing by Zoom. They are with Cincinnati State. There are 3 reasons why the dismissal by the court below was perfectly appropriate and should be affirmed. The failure to state a claim, the doctrine of res judicata, and the lack of subject matter jurisdiction. Frankly, no matter what theory the plaintiff has tried to assign to this claim, first it was replevin, then the complaint was amended, and the assertion of the remedy of equitable restitution was set forth, which is really another remedy for unjust enrichment, which I would point out the Court of Claims absolutely did rule upon and dismiss, and that is in the last page of that decision. Whether it's just a request for the return of the equipment, whether it's a taking, whether it's a title issue, ownership issue, and as we have heard repeatedly, Duke Energy still relies upon a contract which has been declared void. No matter however you look at it, the bottom line is that Duke Energy One had its day in court. It had that day in the Court of Claims, and it was denied any further relief. Duke Energy One could only
Attorney Smith,
yes.
how would you distinguish this on res judicata grounds? How would you distinguish this from Rawls versus Lewin?
And Rawls versus Lewis, and I'm afraid I'm not quite clear in regard to what Rawls stood for, but as far as res judicata is considered, everything that is before this court was before the court below and was appropriately before the court. That would be the complaint, the memorandum in opposition that was filed by Duke Energy One, and most importantly, the decision of the Court of Claims. And in that, there's no issue of fact. There's no issue of what happened in the Court of Claims, and that's what we normally see in cases where summary judgment is determined to be appropriate as opposed to dismissal. But there's no issue here as to what the claims that were pled below, and that this was the same parties the same claims and the same remedy in the Court of Claims.
Was it proper for the trial court to consider what happened in the Court of Claims on a motion to dismiss rather than a summary judgment motion?
Yes, and we have cited a couple of cases in our brief that stand for the proposition that dismissal is appropriate, where one, this was a decision of another court, which again decided the exact same issue that has been brought to this court. The same claims, there's no issue of underlying fact. A lot of times in these cases where summary judgment is determined to be appropriate as opposed to dismissal, it's because it's unclear as to what the claims were, whether they embodied the same issues, whether they embodied the same parties, whether they embodied the same facts. There is absolutely no dispute here. And in fact, Duke Energy 1 in both instances attached the exact same documents, that is the contract and the service agreements, which were declared void by the Court of Claims. If one looks back at the original complaint, that is what was, there was actually no mention of the fact that those contracts had been found void by the Court of Claims in the first complaint. But as noted in the motion to dismiss that very first replevin claim, that document was brought forward, that the court can take notice of that. That is a public filing. It is a public record. And again, they're about what that court decided, the Court of Claims, there is absolutely no dispute. And frankly, if there was a dispute about the case in the Court of Claims, it should have been appealed to the 10th Appellate District. And what we have heard here from Duke Energy is that its claim for unjust enrichment wasn't ripe. Well, that essentially goes to the issue of whether there is even subject matter jurisdiction, or whether, and in fact, the Court of Claims had exclusive jurisdiction over all of the claims that should have been brought. One does not bring breach of contract in Miami County, express contract, breach of implied contract in Montgomery County, and unjust enrichment in Hamilton County. And the Court of Claims statute itself recognizes that one, claims for damages must be brought in that forum, and that it also has equity jurisdiction. In fact, Judge Crawford, in denying any further relief to the parties, expressly dismissed the unjust enrichment claim. To allow any claim to go forward once the technical requirements have not been met in a contract that has been entered into by the government, the state, a county, or the city, to allow it is to actually ignore or to annul the statutory requirements. These are not mere technicalities. This is, in fact, the law of the Ohio Supreme Court when it has determined, going all the way back to Buchanan Bridge, which Buchanan Bridge is not outdated, as we pointed out in the Shampton case in 2003 and the Lathrop case, which has been cited therein, and all of the cases cited. This is a long-standing doctrine. And why is this? Why is it that the parties will be left where they are? Why is it that equipment and infrastructure should not be ripped out? Again, Duke Energy wants to come in and rip out this equipment, this infrastructure, which would shut down Cincinnati State. It goes to all of its electrical infrastructure. And in fact, Cincinnati State has paid millions of dollars already under this void contract. And so the parties need to be left where they are. Cincinnati State has already paid the money. Duke Energy is not entitled to the equipment back, and neither is Cincinnati State entitled to its money back. The reason why does it seem unfair? The Ohio Supreme Court has made the determination that it is better that the sophisticated party bear the loss, this being Duke Energy 1, as opposed to the public and the public coffers, the public taxpayers. That has been the long-standing position that was first espoused in Buchanan Bridge. The issue of ownership by operation of law The bottom line is the equipment stays. The equipment stays with Cincinnati State, and Duke Energy One gets to keep its money. Therefore, the question is, the public coffers should not have to pay for a negligent or hapless government employee.
Attorney Smith, I just want some clarification. In the Buchanan case, I believe that the equipment was sold, or the materials were sold, and the bridge was already built, it had already been used. In this case, is there any dispute that Cincinnati or that Duke Energy was not selling the equipment? It was it was still belonged to them during the course of the contract when it was before it was declared void?
Well, in regard to Buchanan Bridge, first addressing the fact that the equipment was, that the supplies were sold, they never were paid for. So that transaction did not take place, right? The materials and the labor, right, occurred. The materials were put into the bridge, and was there a sale? They never were paid for, okay? But the bridge remained.
But that was the intent of the parties originally, correct?
Oh, well, I think the intent of the parties would be for that equipment and for that labor to have been paid for.
Correct.
So I see what you're saying, that it was intent. Looking to the intent of what the parties here held goes to the voided contract. And we would submit that the court cannot look at that because the Court of Claims has declared that the contract is void. And whether this was a sale or a lease, again, is not something that this court is permitted to evaluate because, one, the contract was void. It's as if it never existed, not simply voidable, but void. And secondly, if that was an argument to be made, it should have been made in the Court of Claims. And that's where we come back every time, is that these arguments should have been raised in the Court of Claims. You know, res judicata stands for not just what was decided, but also what could have been decided. So even if the position of Duke Energy One is accepted, that for somehow the unjust enrichment claim wasn't decided when the clear language of the decision says that it was, and says that we will leave the parties where they are. So all of this was before the Court of Claims, then that decision should have been appealed to the 10th Appellate District. If Duke Energy One didn't like Buchanan Bridge and didn't think it was applicable, then it should have been appealed to the 10th Appellate District. That court had the exclusive jurisdiction over those claims. I would point out that, again, that Buchanan Bridge continues to remain good authority. As recently as 2003, the Shampton Court noted, and in Shampton, it struck down a long-term lease where, in fact, the tenant had made substantial investment in city-owned property, had put its own money into city-owned property. And in those circumstances, the decision was again held that an occasional hardship may accrue to one who negligently fails to ascertain the authority vested in public agencies, but the loss should be ascribed to its true cause, the want of vigilance on the part of the sufferer. And that would be, in this instance, the sophisticated entity, Duke Energy. So again, perhaps there may have been an issue of intent in the Shampton case. It was a lease, but again, we don't look at that because the contracts are void. And the decision of the Supreme Court is that the parties will be left where they are. There is absolutely no authority that can be cited, and little authority has been cited, frankly, by appellant in this. The issue, again, of intent of the contract and relying repeatedly on the contract is what this court is not permitted to do at this stage. And the Court of Claims decision should be granted the full effect that it has been given, It had the jurisdiction, it had the exclusive jurisdiction over this. Res judicata is appropriate, and frankly, whether this court wants to consider it in its de novo capacity as a summary judgment issue, that is perfectly within this court's authority. It doesn't matter at this point. Again, the record is complete, and there can be no dispute that the parties should be left where they are, and that the claim should be dismissed. Thank you very much. Unless there are any further questions. Thank you so much.
Thank you. Attorney McMahon, you have your 5 minutes.
You're muted, Mr. McMahon.
That would help. Thank you.
Perfect.
I would like to address a few arguments raised by counsel and some questions by the court. On the issue of the declaration that the contracts were declared void and counsel's statement that whether a sale or a lease is not something this court can evaluate, I strongly disagree with that. The fact that a contract is declared void simply means that the contract cannot be enforced. It cannot be enforced in the court of claims case. Duke could not recover money in the court of claims case. That's it. It doesn't mean that it's not, you just tear it up and dissolve it into air. The piece of paper still can be evidence of the party's intent. It can still be used in a deposition to cross-examine someone, to ask what was the agreement of the parties. It can still be, as in this case, attached to a pleading to identify the party's agreement. And it was in fact attached to the amended complaint and is incorporated by reference to the amended complaint and is part of the pleadings in this case for purposes of Civil Rule 12b-6 and 12b-1. So I disagree, and the appellee has not cited to any authority on their side that says this court has to act like it doesn't exist. It is part of the pleadings in this case. The court must consider it. In fact, I would say the opposite is true. It has to consider it. And I'd like to go back to Judge Bach's question to counsel about the ownership of the equipment. That is a critical fact, and I mentioned this in my opening argument. It's a critical distinguishing fact between this case and Buchanan Bridge, because when under the theory and the principle of Buchanan Bridge, leaving the parties as they lie, and I understand the reasoning, and you know, and I think it's a somewhat antiquated. I'm not going to try to re-argue Buchanan Bridge from more than a century ago, considering the massive, power of the state and the resources that the state have, the Ohio Attorney General's office and the firm and the resources that it has present today and everything else. But be that as it may, as they lie, Buchanan Bridge, they intended to sell the materials to the state. The personal property there, the construction materials changed hands. Yes, they weren't paid for, but they changed hands. They were delivered to the state. They were incorporated into a roadway that was constructed on state property, into a roadway that was used by the state. Title essentially to this, these materials had changed hands. That's not what happened here. The party's intent here was always that Duke Energy One would own this electric equipment, as confirmed by the allegations of the amended complaint and the documents attached thereto. So leaving the parties as they lie means that Duke Energy One still owns the property. So what is the company to do at the end, when the court, at the end of the Court of Claims case, as counsel says, Judge Crawford says, the courts will leave the parties as they lie. Okay, we ask for our property back because no one has ever said we own, that Cincinnati State owns the property. Now that the court has declared our contracts void, we want our property back. And Cincinnati State, for the first time ever in years, At no point during the Court of Claims case said, no, we're not giving it back because we think Judge Crawford's decision means we now get to keep your property. That was the first time they ever made that assertion. They made it once during the course of the Court of Claims decision. We would have had notice and opportunity to litigate that issue in the Court of Claims. It is patently unfair to do it after the fact. It absolutely is, it's offensive. It's an unconstitutional taking of personal property. After the fact, we had no notice or opportunity to litigate this fact in the Court of Claims, and to make this argument later is unreasonable. And to come back later and say, oh, sorry, res judicata, you should have argued this fact when, oh, yeah, we never argued it, but we're gonna claim that we now own your property worth hundreds of thousands of dollars, even though we never thought we could, but we're gonna take this opportunity to claim that we now own it because of Cannon Bridge. Well, tough luck. That's not the law. No case in Ohio has ever held accordingly, neither Buchanan Bridge, its progeny, nor any other case in Ohio. And under 12B1 and 12B6, the trial court should not have dismissed Duke Energy One's amended complaint. In this case, Duke Energy One asked that this court reverse the trial court's decision, remand this case for full adjudication on the company's amended complaint back to the trial court. And I thank you for your time.
Thank you both for your arguments this morning. We will take the matter under submission, issue you a timely decision, and we wish you both a wonderful Thanksgiving.
Thank you. You as well.
Thank you. Good morning. This is our second case this morning, case number C210278. Marlon Hill Sr. versus Taisha Ferguson. If attorneys can please identify themselves and their readiness to proceed.
Yes, Your Honor. Thank you very much. Sierra Kazi, Esquire from Tibbs Law Office for Respondent Appellant Taisha Ferguson, and I am ready to proceed.
Good morning.
And Jeff Kutcher, attorney for Marlon Hill, the petitioner appellee, ready to proceed.
Good morning. Attorney Causey, would you like to reserve time?
Yes, Your Honor. I would ask that I reserve 2 minutes for rebuttal.
All right, whenever you're ready, you can start.
Thank you, Your Honor. May it please the court, my name is Sierra Kazi, and I will be arguing for appellant respondent Taisha Ferguson. There are 3 issues today that are presented for argument. That is that the trial court erred in allocating parental rights and responsibilities in parenting time in the DVCPO. Number 2, the trial court erred in ordering the DVCPO be granted until April 13th of 2022. And number 3, that the trial court erred in finding respondent committed an act of domestic violence as defined in Ohio Revised Code 3113.31A. Starting with the first assignment of error, a CPO can allocate parental rights, responsibilities, and parenting time if no other court has determined or is determining these issues, as under Ohio Revised Code 3113.31E1D. In our current case, Hamilton County Domestic Relations allocated parental time in the DVCPO by suspending respondents' parenting time with the minor child. However, the Hamilton County Juvenile Court had already exercised jurisdiction and had already had in place a parenting time schedule between the appellant and appellee, the respondent and the petitioner. Because they had already exercised jurisdiction in this case by making that parenting time order, that this court cannot now determine these issues. The Hamilton County Domestic Relations Court cannot now determine those issues. If a court does determine those issues, that judgment of the domestic relations court is possible to be voided. It is voidable, as in our In Re JJ and Couch versus Harrison. In Re JJ, the court found that the judgment was not voidable in that case. However, it's very important to distinguish the differences between the current case at hand and that case. In that case, the case was transferred from a variety of visiting judges within the juvenile court. However, this case has not been transferred. These are two separate cases that have occurred involving parenting time, involving the juvenile court and one involving the domestic relations court. If there were previous cases involved, then they would be able, if it was the one same case, then they would be able to review previous orders and easily review the same facts, same evidence, things like that. However, that's not the case here. Although this, excuse me, Your Honor. Although there was an untimely objection in this case, the motion to set aside was not timely filed with the Hamilton County Domestic Relations Court. However, that does not prevent plain error. Plain error is any error that seriously affects the basic fairness, integrity, or public reputation of the judicial process, as in Hoyt versus Hindle.
Now, you're saying that it was untimely filed. When was it filed? How many days?
Your Honor, I believe it was 17 days.
Okay,
Thank you.
it was 17 days.
I believe so. However, I'm not quite sure off the top of my head. In Hoyt versus Hindle, the juvenile court had previously determined parenting rights and responsibilities as well as parenting time. The domestic relations court, then through a DVCPO, disturbed this previous order by reallocating those rights. Even though the respondent in this same case did not object to the jurisdiction to the trial court at the trial level, the jurisdiction of the domestic relations court, the court determined that this constituted plain error, which is very similar, almost exactly the same as our current case here. Now, the court does say that unless there is an immediate need for a DVCPO, that these cannot be granted. So any kind of immediate remedies that are available, strike that, Your Honor. So moving on to the second assignment of error, the trial court erred in ordering the DVCPO be granted until April 13th of 2022. Under the law, determinations made by the domestic relations court on an interim basis that are used to protect children from imminently dangerous situations should only remain in effect until the court of proper jurisdiction can properly review this matter. So we have to look to the facts of this case to determine whether something was imminently dangerous or not in this certain situation. We had two experts.
Counsel, would this also be under a plain error review, this assignment of error?
Yes, Your Honor, it would. So we had two expert witnesses testify at trial, and both of them testified that there were no safety concerns with mother currently, which is the respondent. Petitioner even offered to let respondent have supervised overnight visits, which also lets us know that this was not a concern with the imminency of the danger to the child. Further, petitioner delayed in taking the child to the hospital for the marks on his face, which again adds an element to the non-imminency that was present. This was not an emergency situation. Even if the court decided that it was an emergency situation, petitioner has had enough time to file in the juvenile court of proper jurisdiction. However, there has still not been anything modifying custody or asking for permanent custody of the child filed in juvenile court, which is the proper jurisdiction. There has not been any kind of alterations to parenting time filed in this same court.
Doesn't Mr. Hill already have full custody?
He does have full custody. However, there is an order out of the juvenile court allocating parental rights and parenting time, rather. So moving to assignment of error number 3, the trial court erred in finding respondent committed an act of domestic violence as defined in revised code 3113.31A. Under 311.31A1A2, the petitioner must prove that respondent placed another in fear of serious imminent harm. However, no witnesses testified to this, and they actually really did the opposite as stated before. Under 3113.31A1A3, petitioner must prove respondent abused the child as defined under revised code 2151.031. These two are two different definitions of domestic violence, and if one is met, then the protection order should be granted. However, under this definition, considering whether or not the minor child was abused, we have to remember all of the initial information about the minor child came from petitioner, who respondent had filed a contempt on against a week or so before. Petitioner was the one that spoke to hospital staff about the incident, and the hospital staff continued to rely on this source for this information. The reports were continually read by hospital staff, and those reports were based on the initial interview with the child's father.
Counsel, I'm a little confused here. I was reading the record. I was under the impression that the child informed a social worker at the Mayerson Center that his mom had struck him in the eye with a toy bat. Is that incorrect? Did he not tell other adults that happened?
So that is correct. However, if you read the record, the Mayerson Clinic interview actually happened after a series of other interviews with medical staff.
And didn't he tell other adults the same thing?
Yes, Your Honor, he did.
Thank you.
So going on to that, Your Honor, one of the witnesses, Ms. Freihofer, who interviewed the child at the Mayerson Clinic, could not assess the credibility or truthfulness of the child, and she testified to that at trial. Further, one of the other professionals and experts in this case, Ms. Dornbush, who worked for Children, Job and Family Services of Hamilton County, reported that respondent's friend and respondent's other child all told her that respondent's other child who was in the home hit the minor child that is on the DVCPO. Now, I understand that the motion to set aside was untimely filed. However, I think that many of these, especially number 1, which the court has already previously ruled is a plain error. However, the other 2 errors definitely seriously affect basic fairness of the judicial system and challenge the legitimacy of the underlying judicial process. So at the end of this case, Your Honors, we would ask the court to hold this judgment as void for lack of subject matter jurisdiction and or reverse the decision by the trial court. Thank you.
Thank you. Attorney Kutcher, whenever you're ready.
Thank you, Your Honor, and may it please the court. First, I guess I'll comment on the motion to set aside that counsel indicated was filed 17 days after the order. My review shows that it was filed April 28, which was 14 days after the protection order was issued on April 14th. The respondent appellant.
So for a protection order, well, how much time does one have to file an objection?
Well, they have 14 days. And that's where I'm going next, is that the respondent appellant titled their objection or titled their filing a motion to set aside. And so when we look at what a motion to set aside is you move to set aside an order of the court, the deadline there being 10 days, as opposed to objecting to a magistrate's decision, which is a 14-day period. Now, quite
Now,
frankly,
how is it ultimately treated by the trial court?
by the trial court, it was treated as a motion to set aside under, I forget what civil rule, but whatever civil rule deals with motions to set aside, it was treated as a 10-day time frame by the trial court. Now, quite frankly, I think the trial court probably should have, even though it was titled incorrectly, even though it didn't cite Rule 65.1, which is very specific to domestic violence protection orders. I frankly think the trial court should have considered it an objection to the magistrate's decision, but they didn't. The respondent appellant did not title it that way, did not reference that it was being filed under Civil Rule 65.1, and further did not appeal that decision of the trial court, maybe with an argument that it should have been treated as an objection. So with all that said, I'll take the respondent appellant's concession that this should be treated as plain error.
Okay.
And
Well, what's interesting though is if it was a motion, if it was an objection, then we would be divested of jurisdiction over this matter, would we not?
the
Because it
trial
would have been a timely objection,
the trial court should hear that objection.
right?
Yes. And frankly, I think that the trial court should have read it that way, but they didn't, and the appellant didn't appeal that decision. So I do agree with the court on that position. With the appellant conceding that it's a plain error review, I'm sure the court knows that in civil cases, plain error is not favored. It's to be used only in extremely rare cases involving exceptional circumstances. And there's a citation to Goldfuss versus Davidson that I'm sure the court's well versed in.
Right. Well, all is waived but plain error review.
Correct. So the appellant talks about the magistrate in this protection order allocating parental rights. And the appellant relies on the Hoyt case, which is out of the 11th District, Lake County. And the thing about Hoyt is that was a case that involved actually two protection orders, that there were separate protection orders as I read it against the mother and the stepfather. In that case, the court took up on the task of truly allocating parental rights in that they got involved in who should have custody and where visitation should occur, specifically where visitation should occur and when. My argument here is that the trial court did not allocate parental rights. All the trial court did is issue this emergency order to protect a child who cannot protect himself. And specifically in paragraph 6 or box 6 of the protection order, the trial court specifically says any subsequent juvenile court order amending or modifying respondent's contact with the protected party may supersede this order. I read that as an invitation for the respondent appellant to immediately, right after April 14th, go to the juvenile court and ask for some modification of visitation such that the child remains protected, and allow that juvenile court order to supersede this order. Instead, the appellant has taken this much lengthier task through the Court of Appeals, arguing, I guess, that this order is void and should never be in effect in the first place. But simply, my argument to point one is that this did not allocate parental rights. This invited the respondent to go to juvenile court to reallocate those parental rights or reallocate the visitation schedule such that the child would remain protected. The appellant also argues that the trial court should not have issued a 1-year period of protection. I think this is consumed in the allocation of parental rights. I think the 1 year is completely appropriate. The appellant's argument, I think, on this point is that as petitioner, Mr. Hill should not have gone to the domestic relations court to get this emergency order, but rather should have gone to the juvenile court to begin with. But as your honors noted in appellant's argument, father already has full custody. He's not seeking to change that. The thing he sought was emergency protection for his son. And we did so through the domestic relations court, and the open invitation is there for respondent to go back to juvenile court. The third point of the appellant is that there simply wasn't an act of domestic violence here to begin with.
Well, I'm not sure is part of the point of the appellant that perhaps the trial court, while it may have had jurisdiction over the protection order, but it would not have had jurisdiction over amending any of the custodial determinations, that was vested in the juvenile court.
I would agree
How would you address that part?
I would agree that the custodial determinations remain in the province of the juvenile court. The appellant pointed, your honors, to one subsection of 3113.31. But in that section, subsection E1H tells us that the trial court may add restrictions provided that they're equitable and fair. And this was a big deal in the Hoyt case, where the trial court put all kinds of restrictions on what the mother and the stepfather could do and not do. This trial court didn't do anything like that at all. This trial court did issue a blanket 1-year protection order, but the remedy there this trial court didn't then further allocate parental rights at all. This court invited the appellant to simply go back to juvenile court and see what could be worked out there.
Counsel, I have a question about the Hoyt case. I just want to make sure that I was reading this correctly. In that case, the Court of Appeals determined that the allocation of custody was plain error, but left in place provision similar to what was in place in this case. Is that correct?
I agree with that. The ultimate decision in that Hoyt case is that the civil protection order was upheld by the Court of Appeals. The civil protection order was valid. The custody determination was not appropriate. That was plain error. That was such a big deal. That was plain error. That was for the juvenile court to figure out, because the parties weren't married and they had the prior determination from the juvenile court. And in addition, the Hoyt case put other restrictions on, and those restrictions were found to be not equitable and fair because they weren't related to the conduct that was trying to be prohibited.
Okay, thank you.
So I think this gets us to the final point where appellant argues there simply wasn't an act of domestic violence at all. Now, if I'm right, I think the standard is that we had to show by a preponderance of the evidence that the child is in danger of domestic violence. I think, I just really submit on the record, I think the evidence is just overwhelming that the child talked to multiple different adults on multiple different occasions. It's in the record that all those conversations with the adult were consistent. And appellant says something about the child going to the Mayerson Center after speaking to other professionals. Well, I mean, obviously that's true. You go to Children's Hospital, you get evaluated, you get referred then to the Mayerson Center, as I think Ms. Freihofer detailed for us. And so of course that interview, that forensic interview, is on some future date. So I think the evidence is just overwhelming that mom acted out of line and committed this act of domestic violence. And we needed this protection order. And the remedy, there's a remedy that exists for the respondent appellant, which is simply go back to juvenile court and ask the magistrate to further allocate parental rights that they were not allocated by the trial court here. That's all I have. Thank you.
Thank you.
Thank you, Your Honors. To respond to some of the things that Attorney Kutcher said. So we spoke a little bit about allocation of parental rights and responsibilities in parenting time. That court in the Hamilton County Domestic Relations Court did suspend the parenting rights of the respondent. Now, Mr. Kutcher compares our case at hand to Hoyt and says that Hoyt holds a variety of different regulations. And while that is true, and while our case does not hold a variety of regulations around the parenting time and parenting rights, there was just a blanket provision. So if anything, there is a more aggressive stance on the determination of whether respondent can have parenting time or not. This order blocked all phone contact, blocked all visual contact, spatial contact, any kind of parenting time, and didn't provide for that at all. Further, in Hoyt, the visitation determinations were reversed, which should be done in this case as well. While the custody determinations were reversed as well and referred to the juvenile court, the visitation provisions were reversed as well. As for suggesting that the respondent go to juvenile court and resolve that issue, that is a possibility for a respondent. However, the issue at hand is that this court, the domestic relations court, should not have been making these decisions in the first place. In the future, respondents should not have to appeal a decision or go through this rigmarole in order to, have to go back and modify things. These things should be left to the court that they were in the original jurisdiction of, which is the juvenile court. There are remedies available in the juvenile court, including emergency motions for parenting time, for custody, if that exists, neither of which were filed in this case. Mr. Kutcher suggests that the 1 year amount of time for the civil protection order is reasonable. However, the court has already held that these protection orders must be granted on an interim basis in an emergency if there is another court that has jurisdiction over the parenting rights and time of the child. 1 year to me is not an interim basis. It is not a short amount of time. And given the fact that it suspended all parenting rights, all contact between respondent and the minor child, I don't believe that the court should uphold that. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and we will issue you a timely decision. We wish both of you a wonderful Thanksgiving.
Thank you.
Thank you, Your Honors.
Thank you. Good morning. This is our third and final case scheduled for argument this morning. This is case number C210207, Robert Bonificio versus Raymond Storage Concepts, Inc. If attorneys can please identify themselves and their readiness to proceed.
Morning, Your Honors. My name is
Morning.
Justin Whitaker. I'm appearing on behalf of the appellant, Robert Bonificio. And I'm ready to proceed.
Perfect.
Good morning, Your Honors. Michael Hawkins, along with John Kelly and Lindsay Boyd from Dinsmore, ready to proceed on behalf of Raymond Storage.
Okay. Will you be the only one arguing this morning?
Yes, Your Honor.
Okay, thank you. Attorney Whitaker, would you like to reserve time and how much would you like to reserve?
Yes, Your Honor. I'd like to reserve 6 minutes.
6 minutes. You can start whenever you're ready.
Thank you, Judge. May it please the court. Good morning, opposing counsel. Good morning. We're here today on the appeal of Robert Bonificio from an order from the trial court below on a motion to dismiss under Civil Rule 12b-6. The facts and procedure of this case are pretty straightforward and relatively undisputed. On June 10, 2019, Raymond Storage and Mr. Bonificio entered into an agreement to hire Mr. Bonificio as a sales account manager pursuant to a written offer letter, which Mr. Bonificio accepted in writing. Included in the employment agreement are three distinct items of compensation. The first is that Raymond would pay Mr. Bonificio $50,000 a year. The second is that Raymond would pay Mr. Bonificio a guaranteed commission of $5,000 per month through December 2020. And the third is that Raymond would pay Mr. Bonificio an automobile allowance of $750 a month. Subsequent to this hiring, Mr. Bonificio and Raymond Storage executed a second document entitled a compensation plan. Raymond terminated Mr. Bonificio's employment on August 3rd, 2020. After that, the parties entered into some informal negotiations to try to resolve the matter. Raymond retained Dinsmore prior to the filing of the complaint, and Raymond's counsel knew on September 10, 2020 that Mr. Bonificio had filed his complaint because I emailed Mr. Hawkins a copy of the same. Raymond therefore had actual notice of the filing date of the complaint and the date of service. Now, what's important here, Your Honors, is that this is a very straightforward and simple case of contract formation, and the time-honored elements required to form a contract: offer, acceptance, consideration, a bargain. When the parties executed the offer letter and Mr. Bonificio accepted it, they entered into an employment contract. At that point, Mr. Bonificio was no longer an employee at will. Raymond argued below at the trial court that the compensation plan incorporated and subsumed the offer letter into one agreement. The compensation plan changed some of the terms of the agreement. However, because at the time Mr. Bonificio foisted the compensation plan, he was not at will, and the employer, Raymond, didn't assume any obligations that it didn't already have. Therefore, there was no consideration for the formation of the compensation plan. That's the Morgan Lump.
You're saying that he was no longer at will. Was there a term of employment that was articulated within the employment documents?
Yes, Your Honor. The employment agreement was to go through at least December 2020. There was a term of time, there was compensation, there was a description of services to be provided. And under the Morgan Lumber and the Rhodes case that this court decided, without compensation, without additional consideration, and where the position and duties and the nature of the business remain exactly the same as before, and the employer reserving the rights to discharge an employee at any time does not assume any obligation which he did not already have. Therefore, there is no consideration when the parties entered into the compensation plan. Mere continued employment is not enough without additional consideration when an employee is not at will. The Copeco case relied on by Raymond cites Morgan Lumber approvingly for that proposition. The Collenberg case Raymond relies on also makes this distinction. So at best, if the compensation plan integrated the parties' agreement at all, which Mr. Bonificio denies, it's at best a partial incorporation. One reason is because the compensation plan refers to a separate policy regarding vehicle reimbursement. The only other policy before the court and in the record is the employment plan, in the employment agreement. That can be the only possible separate policy that the compensation plan is referring to. The compensation plan also expressly states that it is not an employment agreement. It's not an employment contract. The only employment contract, the only employment agreement before the court is the document the parties executed on June 10, 2019. And the compensation plan doesn't pertain to the exact same subject matter as the employment agreement. It doesn't speak to guaranteed commissions, which is central to the employment agreement. Now, the other item before the court below was Raymond's motion for default judgment under Rule 55. Now, there's no dispute that opposing counsel had actual notice of the date of filing of the complaint and the date of service of the complaint. Raymond failed to timely file its motion to dismiss. Instead, it filed the motion to dismiss out of time, and then later, almost 10 days later, moved for leave to do so in violation of Rule 6B. And filing a motion to file out of time is mandatory under Rule 6B. And the other element of Rule 6B is that the defendant must show excusable neglect for not filing a responsive pleading on time. The only evidence that the defendant offered for excusable neglect was the hearsay document of its Vice President Scott Wolcott. Actually, it was counsel's hearsay affidavit relating what Mr. Wolcott told her about his understanding of the date of filing and the date of service. Now, the subjective understanding of opposing counsel of what Mr. Wolcott believed should not fly in the face of the objective fact that opposing counsel knew the exact day that the complaint was filed and the exact day that the complaint was served. And it's our position that the trial court erred and it erred by not at least holding an evidentiary hearing to allow Mr. Bonificio to cross-examine Mr. Wolcott about his understanding of when the complaint was served. That's the Cathy case. Finally, Raymond has raised a number of issues on appeal for the very first time, which the court should not consider. Mr. Bonificio raised the issue of consideration and the pro rata share of his unpaid salary and vehicle compensation, excusable neglect, and hearsay at the trial court below. Raymond Storage left those arguments unrebutted. There were no arguments in contra of those arguments, and are only now trying to raise arguments contra for the first time on appeal, which, as the court knows, is simply impermissible. If I've gotten to the end of my opening argument, if there's any questions, I'm happy to entertain them.
Let me ask you, Mr. Whitaker, on that, your motion for default judgment, it's my understanding the court never did rule on that particular motion. At least there's not an entry indicating that to be the case. Is that true or false?
Judge, there was no written order, but I believe, and Mr. Hawkins might, I think Mr. Hawkins would agree with this, there was a telephonic conference with the court in which Judge Cooper's staff attorney announced that the motion would be denied. So I don't believe there was a written entry, but there was an oral expression of that entry over the telephone.
Okay, it's I guess the point of my question, if there's nothing in the record and there's no ruling by the court, isn't it presumed that the motion is denied?
Yes, Your Honor.
Okay, all right, thank you. That's all I had. Thank you, sir.
Thank you.
Thank you. Attorney Hawkins.
Thank you, Your Honors. Good morning, and
morning.
appellate
Do you
counsel, good morning to you as well.
Good morning. Can
So-
you start with the
Morning.
there was an assertion that this was no longer an at-will employment situation.
Well, Your Honor, what I would say to that is, as this court well knows, employment at will is well-recognized concept in Ohio, and absent some specific language to the contrary, an employee is presumed to be at will. In the offer letter of June of 2019, there is no term. In fact, it ends up saying at one point in the language, that any violation of prohibition will result in disciplinary action up to and including termination. So do you have any other questions? Let me know. And it just ends up saying that his employment will begin July 1, 2019. So contrary to the appellant's argument, there is no argument that he was not an at-will employee at the time of employment.
I think what he might be relying on is the commission provision that says $5,000 a month through December 2020.
Presuming that he remains employed is the premise that ends up saying. You don't, because you say somebody's going to get a compensation, annual compensation of $50,000, that doesn't mean you're guaranteed employment for a year. And that's the argument of saying that he's not an at-will employee. Also, to address that, and it kind of ties with the language that they say, well, in the subsequent agreement of July 2019, the document that is the combo sales representative agreement and compensation plan, the reference in there to the aspect that there's no consideration or it's not a contract of employment, that again is specifically in that document in reference to the at-will status. In other words, and this is customary in many employment agreements, that they say that this is not a contract that modifies at-will employment. And that's what's made clear in this particular document. The other thing I'll just quickly address is this argument that there's no consideration. Well, that gets to the point of saying he was not an at-will employee, which is contra to Ohio law and contra to the document on its face. And in addition, the document of July 18, 2019, the combo sales agreement, does very specifically provide consideration, obviously continued employment, which is recognized by the Ohio Supreme Court. And secondly, there's a whole set of language that ends up adding commissions, and here's what the company is agreeing to do, and will compensate you accordingly. And so here are all the considerations that are set forth in that particular document, which makes it valid consideration. The other point that I would make, and this is the overall point, is in page 1 of appellant's brief, they say that this complaint, underlying complaint, is based on causes of action emanating from contract law and sounding in breach of employment agreement, referring to the June 2019 offer letter. And they ignore the language in the July 2019 combo sales agreement, which specifically says at the very beginning, this policy takes the place of any and all previous written and oral agreements and is effective February 1, 2019, which also predates the June 2019 document. Furthermore, at the end of that document, the appellant signed where it says, I agree to comply with the conditions set forth herein. So despite what's clearly recognized in Ohio as a merger and integration clause, particularly by the Galmish case and the Shorey case, appellant ignores those principles. And with respect to Ohio law in this regard, the 7th District Court of Appeals in the City of Liverpool case, the 7th District Court of Appeals in 2021 in the Grange insurance case, the 10th District Court of Appeals in the CompuServe case, and all of these citing Black's Law Dictionary and Williston on contracts makes it clear that recitations such that we have in the July 2019 agreement end up clearly being merger and integration clauses that negate the ability to try to argue that somehow this June 2019 document should control. And unsurprisingly, yes.
Mr. Hawkins, was it proper for the court to consider the second document that was signed, the July document?
Yes, we addressed that with the court earlier on, and under Rule 10D, the court must review the compensation plan to determine the rights and obligations of the parties. And that's because when any claim or defense is founded on an account or other written instrument, a copy of the account or written instrument must be attached. And as pointed out in the June document, it does make reference to you are eligible for commissions under the RSCI commission plan. Well, what is that? So that by reference incorporates that document, and that was properly before the court.
Well,
As I was saying,
you're saying properly under 12B6.
correct.
I guess an alternative is that it converted it into a summary judgment.
Well, as we articulated in the underlying pleadings and whatnot, we would argue that it does not, and that the court needs to, in a motion to dismiss, view the documents that are particularly referenced or incorporated by reference in a complaint to analyze that. Relative to the whole integration piece, and then this question of parole evidence, which is basically what appellant is attempting to do here, is bring forth other extrinsic evidence of the prior contract and ignoring the full merger and integration clause. The Ohio Supreme Court and First District have maintained their position with respect to parole in the Bellman case. And, you know, they make clear there that the court held that final written agreement, or in that case, it was a settlement agreement, did not reference any oral agreements, contained no ambiguity, and could not therefore be contradicted by a prior agreement, which is what appellant is attempting to do here. In addition, the court goes on to say the parole evidence rule is a principle of common law, providing that a written document intended by the parties to be the final embodiment cannot be modified by evidence of earlier contemporaneous agreements that might add to, vary, or in this case, contradict the writing of the subsequent document. So they're arguing, well, the subsequent document contradicts the first document. The court's saying if there's a merger and integration clause, that's not appropriate. In addition, and they cite again the Galmish case and also the Shorey case, point out that the duties and restrictions that do not appear in the written document were not intended by the parties to survive. So relative to the subsequent document in July, by not incorporating guaranteed bonuses or a car allowance, they were not intended to survive in the subsequent document. And then citing Williston on contracts, the First District in the Chase Home case made it clear that absent fraud, mistake, or other invalidating cause, the parties' final written integration of their agreement may not be varied, contradicted, or supplemented by evidence of prior or contemporaneous oral agreements or prior written agreements. There's not one shred of evidence that's even been argued or suggested that there was any element of fraud, mistake, or other invalidating cause. And then citing Chase, the First District emphasized again in this Retirement Corp of America versus Henning case in 2019, that absent fraud, mistake, or other invalidating cause, the parties' final integration agreement may not be varied, contradicted, or supplemented by evidence of prior documents. Again, citing that Chase Home Finance case. So when you look at the totality of this and the facts, what could this court do and what should this court do is to affirm the lower court's decision on the dismissal based upon the principles set forth that I've argued and that we argued in our briefs by the Ohio Supreme Court and even this court and other courts of appeals throughout Ohio. Relative to this issue of default, which keeps coming up, I mean, in 40 years of practice, I've never had anybody take a position, oh, well, something's 4 days late, so therefore, you know, it's a default. Most of the time you call up a counsel and, okay, fine, no big deal. But to argue that, well, I sent you a copy of a document, therefore you know the day I filed it, is not the same as when a client tells you that they received service. There's plenty of times when a document's filed and it's typically not served the same day. In addition, as we point out in our briefs, this is not hearsay. This is what counsel, in this case, Lindsay Boyd, relied on in terms of fixing the date. You ask the client, when did you obtain service? This is the day I obtained service. And we relied upon that. And then as we point out, there's been no adverse effect, no harm to the appellant in this case. by, their argument of 4 days late. And in addition, the case law and some of the rules seem to be very clear. Even if you file late, an answer or a motion to dismiss, and it is the first pleading and it's not been adverse to any party, that it's, definitely excusable neglect by any standard. And I would submit that that's a abuse of discretion standard for this court to review. And quite honestly, for the court to have granted a motion for default, it would have been abuse of discretion based upon the rules and Ohio law relative to filing subsequent pleadings. The other thing that I would simply add is you look at the questions about, well, what about this guaranteed bonus or what about these car allowances? Well, the document itself, the subsequent July combo sales agreement and compensation plan, in page 2, Roman numeral 2A3 says this is designed to compensate you as outlined in the compensation program of this document. And on page 11 of the document, Roman numeral 3B, it has a specific headline of commissions and bonus. So the parties, by their agreement, has recognized we have now a new different agreement than whatever you signed in June, dealing with how commissions and bonuses will be paid. On page 5 in 5A, there's a specific section that says auto allowance, which says monthly salary and expenses. And then it says you will receive reimbursement of vehicle expenses as per separate company policy. Well, that offer letter is not a separate company policy. It's an offer letter, and it was negated and rendered null and void, if you will, by the integration clause that says this policy takes the place of any and all. I would also submit that some of the cases that we've cited and that I referenced here this morning by Ohio courts have made it clear that even without that kind of specific language that says this takes the place of any and all prior agreements, that courts have found that agreements that are subsequent to oral agreements or other written agreements are in fact enforced, and that extrinsic evidence about the prior signed documents or oral agreements were not allowed under the parole evidence rule. So with that, we submit our argument to the court. Glad to answer any other questions. And we ask the court to affirm the trial court's decisions.
Thank you.
Thank you all.
Attorney
Happy
Whitaker.
Thanksgiving to everybody.
Thank you. Attorney
Yes.
Whitaker.
Yes, thank you, Your Honor. It cannot be plausibly argued that Mr. Bonificio was an at-will employee upon execution of the employment agreement. There was a term of employment, there was consideration, there was compensation, and there was a bargain for exchange. Mr. Hawkins referenced some conditions of employment, and those conditions were that Mr. Bonificio pass a pre-employment drug screen, criminal background check, alcohol breath test, and motor vehicle record check. He must disclose any restrictions from his prior employment that would impede his then current employment. So certainly Mr. Bonificio could be terminated for cause. Every employment agreement allows an employer to terminate an employee for cause. He wasn't terminated for cause here. There's no indication that he was. So therefore, upon execution of that document, he became an employee not at will. And therefore, any subsequent change to his employment must be met with additional consideration. Ohio law is very clear about this.
Mr. Whitaker, as far
Yes.
as an at-will employment versus a contract employee, Mr. Hawkins referred to case law that said that it has to be explicit in the offer. Do you have any case law saying the opposite?
Not off the top of my head, Your Honor. I'm not aware of any case law that says, in fact, if an employment documents that make an employee not at will or at will typically say this is not an employment agreement. This is an at will agreement. Every employment document I've ever seen explicitly makes clear that employment is at will, not at will, if that makes sense.
But isn't Ohio an at-will state unless it is clear that it isn't?
It is an
That
at will. Yes, Your
I'm-
Honor. It is an at will state, and it's clear from the employment agreement that that the parties intended for Mr. Bonifacio's employment to be not at will by the fact that it had a guaranteed term, guaranteed compensation, the nature of the relationship was explicit in terms of the parties' responsibilities to each other. I don't think it's plausible that employment remains at will when you have guaranteed provisions for both sides. Along these same lines, the appellee is making arguments for the very first time at the Court of Appeals that it did not make at the trial court below. And Ohio law is very clear that the Court of Appeals cannot hear those arguments. Mr. Bonifacio's arguments as to consideration were left unrebutted at the trial court. It could have, appellee could have made an argument against it. It elected not to. And with that, Your Honor, I conclude my argument and ask that the court overrule the trial court's motion for entry granting the motion to dismiss under Rule 12b-6. If there's any questions, I'm happy to entertain more.
Thank you both for your arguments this morning. We will take the matter under submission. We will issue a timely decision. And we also do wish you both a wonderful Thanksgiving.
You too, Your Honors.
Thank you all.
And that